Morning, class. We're going to be talking about the federal judicial system, an introduction to the system for our new unit, and we might as well start with some vocabulary. There's really a couple judicial systems. There's a civil system, a civil case, where you have a plaintiff and a defendant who are engaged in a dispute mainly over money. Okay, the dispute between two or more people or corporations or whatever are referred to as parties. The people involved in a lawsuit are referred to as parties. And when they're fighting over money, it's often called a tort. Okay, a tort is a French word for wrong. And in this context, suffice to say, they call the system of civil system of fighting over money the tort system. Criminal cases are a little different. There's no plaintiff per se. Rather, it's the state, called the prosecution, versus a criminal defendant, somebody who's been accused of committing a crime. Okay, and so it's a dispute between society, as represented by the government, and a person or company or whatever that's been accused of breaking the rules of society, i.e. a law. Okay, now they're fighting over the liberty of that person, because keep in mind that in a criminal case, what's at stake is your liberty. Okay, if you're found guilty, the government will take away your liberty and you have to go to jail or prison. And in our system, since liberty and individual freedom is at such a premium, that's a big deal. Okay, now there's types of trials. There's jury trials where there's a group of people, normal citizens, who judge whether or not the person's guilty, what are the facts of the case. And in those jury trials, the judge sits as kind of a referee on the legal issues. So they're kind of a referee on the legal issues, but the jury decides the case. They decide what the facts are and who did what to who, when, for how much, or whatever. Okay, now there's also what are called bench trials. A bench trial has no jury. It's simply appearing before the judge, and the judge acts as both the finder of fact, what happened in the case, as well as the finder of law, or the adjudicator of legal matters. Did each side do this process right, and did they follow all the rules and that kind of thing? More about that probably next week. But it's always the choice of the person either bringing the lawsuit, whether they want a jury trial in a civil case, or the criminal defendant, the person accused of a crime, to choose in a criminal manner. Now, I want you to take a moment and make sure you put either in your notes or on the Google Doc in the appropriate answer, or in the appropriate question. Why do you think the choice of what kind of jury trial, whether somebody wants a jury trial, is up to the plaintiff or the criminal defendant? Okay, now I'm going to assume you've paused the video and written that down, and now we're going to move on. So, more vocabulary. It's the idea of jurisdiction. Jurisdiction is basically just asking the question, what's the appropriate court level to hear a particular case? So if you have original jurisdiction, if a court has original jurisdiction, that's the first level, the trial level of the judicial system. So at that level, you have a jury maybe, or maybe not. You hold hearings, you have the attorneys asking questions of witnesses, you have documentary evidence, which means papers that help prove the case. And it all happens generally happens at this level, the trial court level. Okay, the trial court level. That's where you have original jurisdiction. Now, these case levels above it, at the appellate and Supreme Court levels, are called appellate jurisdiction. Okay, and that's basically, if you don't like the decision that came out of the trial court, you can ask for a second opinion. And in some cases, you can ask for a third opinion. Okay, so that's the basic meaning of jurisdiction. What is the appropriate court to hear this case? Now, there's other forms of jurisdiction as well. And within the federal court system, district courts have original jurisdiction in most matters. Circuit courts always have appellate jurisdiction. And the U.S. Supreme Court, as we'll find out on Monday, Tuesday, have both. Okay, so it's a system which allows for people to have multiple attempts to have their case heard, and if they don't like the result, they can ask for somebody else to take a look at it too. So here's your basic judicial system layout. Okay, you have trial courts. Okay, whether it's the U.S. district courts, the bankruptcy courts, and by the way, bankruptcy courts, their first level appeal is to the U.S. district court level. So in a bankruptcy matter, you can actually have the trial in the bankruptcy court, the first appeal to the U.S. district court, the second appeal to a circuit court, and then a third appeal to the U.S. Supreme Court. Okay, whereas there's other matters that go directly to special circuit courts that we'll talk about in a couple minutes here. The U.S. Court of International Trade, the U.S. Court of Federal Claims, those are appealed directly to the U.S. Court of Appeals for the federal circuit. There's 12 circuit courts of appeals that are based on geography, who they cover is based on geography, and then there's one nationwide appellate court that handles international trade matters and U.S. Court of Federal Claims matters. Okay. And then everybody appeals ultimately to the highest court in the land, which is the U.S. Supreme Court. Okay. Now, at the U.S. District Court level, that's the trial level for the vast majority of cases, and it's the first level of appeal for bankruptcy courts. There's 94 of them across the country. All right. There's at least one district court in each state. The District of Columbia has one. Puerto Rico has one. And there's one in the 3 U.S. territories of the Virgin Islands, Guam, and the North Marianas Islands. So 94 total district courts. Illinois, I believe, has, let's see here, Central, 1, 2, 3. I believe the Illinois has 4. I'm pretty sure they have 4. There's the Northern District. There's the Central District. There's the Southern District. I think there's one more district. Pretty sure there's 4. We can talk about that. We can double check that in class on Monday. But regardless, each state, depending upon their size, depending upon their geographic region, depending upon their population size, may only have 1 or up to any number of 4, 5, 6. California has a lot. New York has a lot. These are big states, geographically and population-wise. And district courts hear any kind of case. And again, the exceptions are the specialty cases, bankruptcy cases, where they'll hear on appeal, international trade cases, claims against the federal government, IRS cases, those all go to special courts. Okay? But otherwise, in the vast majority of other cases, they're all going to the U.S. District Court. Okay? So, the U.S. District Court is the first level. That's the trial level. That's where you'll have a jury. You'll have direct and cross-examinations, and you'll have, it's where the action is that when you watch TV and you see a criminal show or you're watching a lawyer show, they're usually appearing in trial court because it's a lot more interesting than the appellate court level. The appellate court level is kind of boring. All right, and the reason is because there's no hearings, there's nothing exciting happening except an attorney or two appearing before a panel of judges arguing over some legal minutia, all right, some little tiny piece of law that one side or the other says they did it wrong. The judge screwed up this ruling, and thus we got to talk about this because it prejudiced one client or the other. Well, all the states are divided into 11 circuits, and then there's one more circuit, the District of Columbia Circuit. So for a total of 12 circuit courts. There's 179 justices authorized for those 12 circuits. Okay, plus the Court of Appeals for the Federal Circuit is the 13th Circuit Court of Appeals. So out of those total of 13 circuits, there's 179 justices authorized. Now, there's usually not that many sitting, and they hear any appeals from lower courts. The first appeal to the circuit court is a mandatory appeal, which means the courts have to take it. Okay, every case in America has at least one appeal to the circuit courts. Okay, you don't have a choice. They don't have a choice. They can't turn down a case. They have to hear it and rule on it. All right, and they hear appeals in 3-judge panels. They hear appeals in 3-judge panels. Now, you can see on this map that geographically speaking, the 9th Circuit is this huge circuit that includes Alaska and Hawaii and all this. The 10th Circuit is a big circuit. It covers a lot of states here. The 8th Circuit covers most of the center part of America. The 7th Circuit, where we live, Illinois, Indiana, Wisconsin, is relatively small, but high population. The 5th Circuit includes Texas. The 11th Circuit includes Alabama, Georgia. And then you can see all, the 1st Circuit's up here, Maine, New Hampshire, Massachusetts. 2nd Circuit includes New York, 3rd, 4th, 5th. So, and then D.C., District of Columbia, has its own circuit because, of course, if you're going to make any claims against the federal government, that's where they're going to hear those cases. Okay. So the Court of Appeals, again, for the 13th Circuit, for the Federal Circuit, that 13th Circuit Court of Appeals, has a nationwide jurisdiction. It's the only appellate court that can hear cases from across the country, but they have a very narrow focus on the cases they hear. As you saw in that chart above, you have the International Court of Claims and the Federal Court of Claims feed into this Court of Appeals for the Federal Circuit. Okay, now so what happens beyond that? We get to the U.S. Supreme Court, and there they are in all their glory. Now, this is the only court that's provided for in the U.S. Constitution. All the other courts were created by Congress after the Constitution was authorized. Okay, there's one Chief Justice, and that's this guy sitting in the middle, John Roberts, and 8 Associate Justices. All right, and they are the final authority in determining issues of law in the United States. If you have an issue of law that's been appealed from the trial court to the appellate court, and you didn't like the answer you heard in the trial court, so it went to the appellate court, and you didn't like the answer in the appellate court, so you appeal it to the U.S. Supreme Court. The U.S. Supreme Court can accept your case, or they can turn it down. But if they accept it, they have the power to determine whether or not something that was done was either procedurally proper from a legal perspective, or if a law is even constitutional. And this is that power that we talked about several months ago called judicial review. Right? It's the ability to determine the constitutionality of a federal statute. So with this brief overview of the judicial system in mind, I want you to take some notes or fill out the Google Doc form. Tomorrow in class, we have an activity, and then we're going to keep talking about the judicial system, okay? Have a wonderful weekend.